Thank you for the invitation, for the organizing this conference. I'm happy to see again the group which I have already tortured for a half day in December. But to relieve you a little bit, my topic is let's say this is continuing the subject I discussed for half day in December, namely, if you might remember it, then it's very good, because then you can be satisfied that you memorize well what you have heard. If not, even better, then it's worth to say it again. And so that we discussed the problems of universalism of human rights vis-à-vis the relativism of the human rights system, the activism of the court and the self-restraint, judicial restraint of the Strasbourg court, and also touched upon subjects like subsidiarity, margin of appreciation. As far as I remember, I avoided the concept of shared responsibility, because at that time I had not clear feelings regarding this concept. Now I try to focus on the shared responsibility concept that become very important in the life of the court, but also just shortly mention the subsidiarity and the margin of appreciation principles that are closely connected to it. And then if time remains, going a little bit more deep into one specific case. That I didn't like the case, but I liked one aspect of the judgment, namely the shared responsibility of internet users. If I can, at the end of this meeting, before drawing some possible conclusions. So, coming to the shared responsibility concept, this is basically, how to say, the official approach is that according to Article 1 of the Convention, it is the national authorities who are the primary guarantors of human rights, subject to the supervision of the European Court of Human Rights, and that the court's jurisdiction is limited by Article 19 of the European Convention to ensuring that the contracting states observe their engagement under the Convention, in this sense protecting rights and freedoms defined within the Convention is the shared responsibility of the court and of the high contracting parties. This concept was expressed or somehow named during several high-level meetings of the leaders of the contracting parties. First in 2010 in the Interlaken Declaration, and that this was repeated several times. I omit to mention all these declarations and their outcome. Not just mention again that after 2012, when the Brighton Declaration focused on the importance of the subsidiarity and margin of appreciation principles, this was finally added to the text of the Convention in the preamble that was adopted by Protocol number 15, and that changed the situation in this sense. So, for example, if we approach some judgments, if we look at some judgments after adopting to the protocol and after it's entering into force, usually name a case that has other importance, not because of the shared responsibility and the margin of appreciation, but because of setting up the standards for judicial independence regarding Poland, namely this famous Grzeda versus Poland Grand Chamber case, decided in March of 2025 that concerned the premature termination of the offices of the Supreme Administrative Court, of a Supreme Administrative Court judge. And here the court, among others, relied on protocol number 15, quoted to emphasize the importance of shared responsibility and how this is linked to judicial independence. The judgment underlined that national authorities and courts must interpret and apply domestic law in a manner that gives full effect to the Convention, and the court underscored that the Convention system cannot function properly without independent judges. The court also underlined that the contracting parties' task is ensuring judicial independence is of crucial importance for the functioning of the Convention system. In another Grand Chamber case in Hallet versus Luxembourg, 2023, the court dealt with a case concerning a criminal law fine disclosing to the media confidential documents from a private sector employer regarding the tax practices of multinational companies. And in this case, the applicant himself stressed the principle of subsidiarity and the importance of protocol number 15. But this didn't prevent the court from carrying out a review, both in procedural and substantive sense, of the grounds and criteria used by the domestic courts in applying the Convention. Similar issues could be mentioned regarding the margin of appreciation doctrine that also included in the preamble of the present text in force. And here I'm repeating myself just to refresh our memory that here basically the leading case was Hearst versus United Kingdom, Grand Chamber judgment that also had other far-going consequences in the life of different countries, especially in the United Kingdom. But you might remember what I'm quoting from my December lecture is that in Hearst the court said that there has been much discussion of the breadth of this margin in the present case. The court reaffirmed that the margin in this area is wide, in the territory of public morals, and there are numerous ways of organizing and running electoral systems, and the wealth of differences in historical development, cultural diversity, and political thought within Europe, which is for each contracting states to mold into their own democratic vision regarding the voting rights of prisoners. Let me mention also that in order to maintain a balance between the European supervision of domestic violations of human rights and respect for state sovereignty, the Strasbourg Court has developed the consensus doctrine. The autonomous interpretation of the Convention means that the Convention concepts are to be regarded as parts of a self-governing legal system that must be interpreted independently from the legal systems of the contracting states. The consensus should not necessarily mean consent of all the parties or all the countries, all legal systems affected, but it means rather common ground and or common denominator. As regards some cases that were delivered after the entry into force of the margin of appreciation doctrine, one could mention the Fedotova and others versus Russia Grand Chamber. Let me mention here, underlining the importance of this topic in the life of the court, that every year we start the so-called judicial year in end of January, in the last Friday of January. That means that the president in office delivers a speech, and then an honorary guest is also delivering a speech about some burning topics of the Council of Europe and the European Court of Human Rights. And then before this solemn opening of the judicial year, there is a judicial seminar, the dialogue between courts is named this series. And last year's topic in 2024 was actually shared responsibility and subsidiarity, and a lot of important things were said at this judicial seminar. They also mentioned Fedotova versus Russia judgment in January 2023. Here the court was called to determine the scope of national authorities' margin of appreciation regarding the legal recognition of same-sex marriages. The complaint was referring to private and family life, Article 8, and the court considered, or basically, let's say, repeated his approach that important facets of personal and social identity were at stake in this case, noted that a clear ongoing trend is among the countries of the Council of Europe towards the legal recognition of the same-sex partnerships, even if not marriages. And then the court concluded that the state's margin of appreciation was significantly reduced compared to the situation decades before. And the court went on to consider that nevertheless the states had an extensive margin of appreciation in determining the exact nature of and the possibility of the legal recognition. So so to say, the approach was double-phased, noting that the tendency was limiting the margin of appreciation, but the particular special context of each country might enlarge this trend, might enlarge the possibility of margin of appreciation for the states. So finally, the court observed that there is a clear ongoing trend is emerging towards legal recognition and protection of same-sex couples. No similar consensus can be found as to the form of such recognition and content of such protection. Of course, that we refer to the principle of subsidiarity, and the judgment concluded that it was for the states to decide on the measures necessary to secure the Convention rights regarding the legal regime to be accorded to the same-sex couples. It was not for the court to determine this regime. Nevertheless, as for the concrete complaint, the judgment concluded that, that Russia overstepped this margin of appreciation and failed to comply with its positive obligation to secure the applicant's right to respect for their private and family life. Also, it's often quoted also in this context, in the context of the margin of appreciation, the Yalchinskaya versus Turkey Grand Chamber case, where was a different issue, the conviction for membership of an armed terrorist organization that was using encrypted messaging application. The court was called to assess the applicant's complaints under Article 6, so it was not a moral issue under Article 8 in this case, in light of also the derogation clause of Article 15 that Turkey at that time referred to. And the issue was to determine whether that the life was threatened by a public emergency, and if it was necessary or not to go in attempting to overcome the emergency situation. And the court observed that by reason of direct and continuous contact with the pressing needs of the moment, the national authorities were in principle in better position than an international court to decide both on the presence of such an emergency and on the nature and scope of derogations necessary to avert it. So accordingly, here the court concluded that this part of the reasoning that there is a wide margin of appreciation, and the wide margin of appreciation should be left to the national authorities. But again, the usual turn that nevertheless the parties did not, the states did not enjoy unlimited power of appreciation. And here the court concluded that Turkey had not adduced any detailed reasons before it as to whether specific fair trial issues originated in the special measures during states of emergency, why they were necessary to avert it, or whether they were a genuine proportionate response to the emergency situation. So the court considered that the limitation on the applicant's fair trial rights at the issue could not be treated as having been strictly required by the exigencies of the situation, and in this case found again a violation here, Article 6 of the Convention. The second, constructing element of this issue is the subsidiarity principle. When this principle was introduced to the terminology of the court by the well-known and famous Handicide versus the United Kingdom judgment in 1976 on the issue of obscene books, public morals, and also the national specificities of such sensitive questions. And here the court referred to subsidiarity to acknowledge that the domestic authorities are in principle better placed as international judges to determine what measures are necessary to secure convention rights and freedoms in their countries, repeating or introducing this later quite everyday formula. The court also in the mentioned Fedotova versus Russia case used the subsidiary function. Of course, in a lot of other cases, just I mentioned some grand chamber judgments that are more or less well known. But then, a few years ago, Judge Spano, later president of the court, the Strasbourg court, in articles, especially in one article, introduced the term of age of subsidiarity, that meaning that there is an evolution of this principle, that the subsidiarity principle is taking force and evoluting regarding the counterbalancing elements, and this second phase of the life of the court, the present phase, is characterized by the increased emphasis on the implementation and protection of convention rights at national level, and here the court is analyzing more and more often the so-called process-based review, whereby Strasbourg judges consider the extent to which national authorities have engaged with the Convention principle when reaching their decisions. This term is also referred in the academic literature as procedural review, procedural approach, procedural turn. Of course, this raises the question whether this is if we are accepting this fact, whether this contributes to the evolution of the jurisprudence of the court, or might rather confuse it, instead of the substantial period when the court defined the content and the substance of the convention rights. turning to to investigate whether the processes of the national authorities were well funded to reaching their judgment, and accordingly to say that that belongs to the subsidiary power, to the power of the states, or the court has to intervene even in the subsidiary role to enforce the values and the rights of the convention. Of course, the national authorities procedures might include the legislative procedure, arriving to defining the legal background, the laws of the state, or might be the procedure of the judicial and administrative authorities. Whether during this procedure, the authorities, the courts, did take into consideration all aspects of the case, and then the court accordingly might say that the process was fair and deep at the level of the national authorities, so therefore it remains in the subsidiarity play, or we say that it was not really well funded and the court has to intervene. Now that we look for the forerunners of this process-based review ideology, it's often mentioned, are often mentioned two cases, also as how to say as the start of this process-based review, the two well-known judgments of the Grand Chamber. One is of Axel Springer versus Germany, and von Hannover versus Germany Grand Chamber judgment, both from 2012, that both concern the public, it's well known, but we just mentioned that both concern the publication in the media of articles and photos depicting the private life of well-known people. In the Axel Springer, the applicant company was a publisher of a daily newspaper that published articles about a well-known television actor who was arrested for illegal possession of drugs. The German courts granted an injunction to him prohibiting further publication of the issue, holding that the right to protection of his personality rights prevailed over the public interest in being informed. The court stated that where the domestic authorities have undertaken a balancing exercise between a publisher's freedom of expression and the right of privacy of a person, then strong reasons would be needed to substitute its view for that of national courts. Nevertheless, it found a violation of Article case on account of the fact that the content of the articles could be considered to present a degree of general interest. And the applicant company had confirmed the validity of the information, had made no disparaging comments or substantiated allegations. So finally, the sanctions imposed on the applicant company were capable of having a chilling effect. So finally, it was a violation, despite opening up this wide possibility for the national authorities to do the balancing exercise between private life and public interest in publishing in journals. Von Hannover is well known, had the same background regarding the Monaco prince's family. But here the court found that the German courts had carefully balanced the competing interests and had explicitly taken into account the court's case law. There had been accordingly no violation of Article 8 in the von Hannover case. It cannot go here Grand Chamber issue, but let mention Didi versus United Kingdom. Almost all cases are for the United Kingdom in my presentation. That demonstrated that the court did not see its supervisory function as requiring to conduct a proportionality assessment, when the domestic courts have already done so in accordance with the court's case law. This was a case of deportation of the applicant because of his criminal activity, and he argued that there was a disproportionate interference with his right to respect for private life. And the respondent state, United Kingdom, submitted that the domestic courts had engaged in a full and proper assessment of the applicant's deportation. The court stated that where the domestic courts have carefully examined the facts, applied relevant human rights standards, and as in this case, adequately balanced the personal interest against the general public interest. So here the court does not have to substitute its own assessment of the merits for that of the competent national authorities. So the court also noted that there are exceptions to this rule when there are strong reasons for them, but in this case found no violation. So that for the judicial processes, where basically the second assessment is made, but not in this case, it's not on the substance of the case, arguing proportionality, balancing of conflicting interests, but whether the domestic courts and other authorities did this task correct and proper way or not. The second set of this process-based review is and in my view is much more complicated and for me less persuasive is when the court reviews the legislative processes of the countries. Here again, let me quote the well-known Hurst versus United Kingdom judgment from 2005, when the court reflected that it cannot be said that there was any substantive debate by members of the legislature on the continued justification in light of modern-day penal policy and of current human rights standards for maintaining such a general restriction on the right of the prisoners' vote. But as you know, and I also mentioned that this was on the prisoners, convicted prisoners' right for voting in elections, and the court didn't find that there was an adequate, substantive parliamentary debate on these issues. So it concluded that the nature of restrictions has to be imposed on the right of a convicted prisoner to vote, and this was generally seen as a matter for parliament and not for national courts. So therefore the court did not undertake any assessment of proportionality of that measure. As how to assess the legislative procedure and the legislative choices means that the quality of the parliamentary review is very important in deciding on it, including the operation of the relevant margin of appreciation. So the central question is therefore not whether the state could have achieved a legitimate aim through different means, but rather when adopting the general measures and striking the balance that the legislature acted within the margin of appreciation afforded to it or not. Of course, this margin of appreciation principles application in deciding the fairness and the substantial character of the margin of appreciation, it's not. It must be very complicated, and sometimes it's not definitely persuasive. Also, the critics against this approach also put in the put in the context that this margin of appreciation principle is applied several times automatically without carrying out a substantive assessment of the fundamental rights involved, so that here the Strasbourg court that avoids to enter into the substance of the case and rather, cover its judgment by reference to the margin of appreciation doctrine. which I personally consider a very useful tool, especially balancing between rights of individual rights and public interest. But we have to mention again that this is a specific tool in the hand of the Strasbourg court, good and right, but no other international court uses this reference. Other international courts and literature backing them considers irrelevant this principle, saying that international courts has to decide on the merit of the case that brought before them, and not to balancing whether the national processes were fair or not, or enough. Of course, this is open for a controversy. My personal view that it's especially what I explained quite longly in December, that the historical origins of the Council of Europe and the historical origin of the very first international court that imposed judgments on the judiciary of developed democracies and developed legal systems, a very peculiar situation, and the whole later history of the court was determined by this beginning. And still I think that sometimes our judgments, especially compared to other international courts, I'm not referring to the Court of Justice of the European Union, but other international courts, I think that our judgments are much more effective that those courts' jurisdiction that clearly reject our approach, margin appreciation principle, and propose to conduct in each case an objective analysis of the member state's responsibility based on the legal material, on underlying legal material. The analysis of the margins of appreciation practice is, in the context of the process-based review, is focusing on the connection between the margin of appreciation doctrine and the quality of decision-making by the national authorities. But this deference, how to say, this withdrawal from the objective and substantial judgment might lead to controversial result as well, I have to say. I'm here referring to controversial, in my view, controversial judgment of the court by accident in Animal Defenders versus United Kingdom. That was a 9-8 ruling. 9-8 ruling, so a very divided court, and it was based on the allegation of violation of freedom of expression of the convention because of a statutory prohibition of paid political advertising on radio and television during an electoral campaign. And this NGO, the Animal Defenders International, brought this case to the court because the TV campaign was banned by the Broadcast Advertising Clearance Center in the United Kingdom, and they attempted to have this administrative decision to be revoked by the national courts, but both the High Court and the House of Lords dismissed their claim. The court, in its reasoning, not only praised the extensive deliberation and its quality, but also asserted that the quality of parliamentary and judicial review of the necessity of the measure was particularly important in this respect, including the operation of the relevant margin of appreciations. So they decided that the parliamentary review and also the two-instance judicial review was so extensive and well-funded that the court couldn't find a violation of Article 10 in a in an issue that, in my humble view, was an orbital violation of freedom of expression. But what was interesting, and not because now I'm referring to a Hungarian case, because I had no prejudice regarding this case, but how this process-based review is implied sometimes by the court. While in this UK case, it basically clarified that there was no violation because the parliamentary debate and the judicial review, so the national authorities reviewing of the case was so deep and well-funded and substantial that it couldn't lead to a violation of the convention. In other cases, and I just mentioned one, when I was national judge, this is not, how to say, a reason for excusing the respondent state, but it becomes a standard to apply for the respondent case. And if the respondent case does not imply the same procedure, then it leads to violation. And this was a case decided 10 years after the animal defenders. It was LB versus Hungary. This regarded an issue that the publishing of personal data of taxpayers who were in debt, who were not avoiding paying taxes, but because of this complex system of the entrepreneurs to receiving the income, paying taxes for that, the delays in this procedure, etc., could create a temporary debt of tax payment regarding vis-à-vis the authorities. So this was the issue. And here the court didn't assess this fact that this rule was introduced into the Hungarian legal system in 1995. Because Hungary, as all other Eastern European countries, was not a market economy. Introducing the market economy in the early 90s created really a Wild West situation in these countries regarding not paying taxes and all other, violating all possible rules of economy, of fair trade, and so on. So therefore, they were thinking of what kind of, how to say, punishment or uneasiness could be put on those who are not paying taxes or not on time, and balancing the different personal data, for example, the birth of date that you cannot change, the name of your mother, also, what does poor mother do with the issue, and so on. So finally they decided to publish the home address. First of all, because you can have several home addresses. You can live not where your home is, etc. And so it's basically, so there was the home address. And then this applicant challenged it that it's a very sensitive data, home address, people can go there. Of course, there were cases regarding politicians' home addresses because people were going there to demonstrate and so on. I can hardly imagine that people are going to somewhere just to protest there because who is living there was not paying his taxes on time, but okay. This was a case application received during COVID time, so I was meditating at home. I could just by phone consult the lawyers and so on. I had no prejudice regarding this case. So I saw that the publication of the home address is still the less invasive method for specifying someone somehow. Because also then, as in a lot of countries, people have the same names, both for first name and family name and so on. So the name in itself does not, on the contrary, can violate the privacy right of a lot of other people who have the same name and pay their taxes right way and so on. So, and there was a parliamentary debate in in 95, the government even withdrew the original proposal, and they changed it, and then they found this final solution of publishing, despite the text number, but the text number is not accessible for private persons, so doesn't mean anything, only the name and the home address. The Grand Chamber disregarded this debate in 95, because then later on the tax laws repeated the same provision. Then a few years ago they added some further amendment, not to the original text, but just introduced another provision. So then the Grand Chamber was focusing on the amended provision, which was, of course, was not discussed in depth in the parliament, because since 95 they just repeated the same provision every year in the new tax law. And what the court found here was not the substantive violation, but that the legislative process was not substantive enough. So my dissenting opinion with Judge Wojtyciak pointed out that this was not true in itself, because there was a substantial debate in 95, and here it became a standard. So if a legislative process is not that deep, then there's a violation of the convention. It might be very difficult for countries where basically there are no parliamentary debates, just at plenary level, just at maybe in the committees and so on, but the Grand Chamber disregarded this. And I told them that if we say that the publication of the home address is a violation of the convention, I will not dissent. Then I accept that the majority of the Grand Chamber decided that, I will not dissent. But this process-based approach just really opens up very big questions in me. I went even further, but I don't want to repeat. No, yes. And but what is, in my view, very interesting was Judge Curie's concurring opinion, because he agreed that there was a violation, but he clearly stated that he was very critical with the Grand Chamber's approach, who invalidated the measure based not on the analysis of the merits, but because it had not been preceded by proper parliamentary debate. And Judge Curie rightly underlined that the use of the quality of parliamentary review yardstick substituted the examination of the issue raised by the applicant. Let's hope that this approach will not be extended in the future, and we stopped at this stage. Of course, then we can see that this process-based review as such might raise serious questions, but let's hope that the court and the wisdom of the court will find a moderate approach to it. Let me turn to the final issue what I mentioned in the beginning, namely an interesting case delivered by the court on the shared liability for internet user speech in the Strasbourg case law. And this case is Sanchez versus France, a Grand Chamber case. I was not part of it. I'm reading with the eyes of an independent observer. Some judges of the present here were members of the composition. Probably know better the case as me. I'm approaching from someone interested in Article 10 issues. And this judgment was delivered in 2023. And here the court was called to determine whether the fact that an elected politician was fined for failing to delete Islamophobic comments made by third parties on his Facebook constitutes a violation of Article 10 or not. So here the issue was that a certain Sanchez who was running the local electoral procedure opened a Facebook wall open for comments and so on. And let me say that his career was not interrupted by this fine put on him, because later he became the not only mayor but also the vice president of Marine Le Pen's party. And two people made comment on this Facebook wall regarding the situation in the southern city of Nîmes. And one said that in Nîmes there's not a street without a kebab shop and mosque, drug dealers and prostitutes reign supreme. Nor surprise he's chosen Brussels, capital of the New World Order, blah, blah, blah. And this blogger SB thanked the mayor of Nîmes and sent to kisses to the, and was happy that the blog of the Sanchez will change our life. The second comment put on this wall was that shisha bars all over the town center wailed, "Women, look what's become of Nîmes, the so-called Roman city," etc. So the authorities decided that basically these two very aggressive and offensive comments, the Sanchez as putting or creating this Facebook wall is responsible for these remarks that incite for violence against an individual and public official, the present at that time mayor of the city, and state authorities enjoyed a broad margin of appreciation on this issue, that they find the owner of this Facebook wall because of the comments. He didn't comment on them. His sin was that he didn't deleted immediately these two blocks from his website, and here basically the court decided that regarding the broad margin of appreciation of the French authorities in assessing the necessity of a given interference, then expressions inciting and justifying hatred based on intolerance and religious intolerance, etc., do not enjoy the protection afforded by Article 10 of the Convention. And also the court went on to apply its established case law on the liability of third-party comments on the Internet, taking into account the specific circumstances of the case, as the Islamophobic nature, the political contest of the elections, the reasons given by the French authorities for imposing the fine on Mr. Sanchez. And the court also reiterated that its task is not to take the place of the competent national authorities, which moreover enjoy a margin of appreciation, to which the preamble of the Convention now refers expressly, but the court's task is rather to review the compatibility with Article 10 of the decisions taken by the national authorities under the margin of appreciation principles, and the court found that the decision of the domestic authorities, namely the fine, was based on sufficient reasons, both as to the liability attributed to the applicant for the unlawful comments and as to this criminal conviction, and the interference with Article 10 was necessary in a democratic society. I completely disagree with part of the reasoning I mentioned already to Latif, and I share the view of the four dissenting opinions of four judges in dissent. But this is not the issue here. The issue is the part that I like, that here the court entered into the examination of the shared liability of the different actors of using the internet. Because here, as you know, the court approach to this issue in the very well-known Delphi versus Estonia Grand Chamber case regarding the liability of a major internet news portal, and in the view of, but under Sanchez, the court addressed this question in the light of the duties and responsibilities mentioned in the second paragraph of Article 10, incumbent on political figures when they decide to use social networks for political purposes, in particular electoral purposes, by opening publicly accessible forums on the internet to gather comments, reactions from those who are reading that. And in the court's view, that the liability of a social network account holder for the comments of third parties does not raise any difficulty in principle, provided that there are guarantees for the implementation of its liability and that it takes place within a framework of shared responsibility of all the actors involved. That's what, despite the final outcome, is a very important, so to say, procedural approach of the court, which I really like. And so that means that where it is appropriate, the level of responsibility and the terms of its engagement could be graduated according to the objective situation of each party, whether it is the host, the professional who creates the social network at the service of the users, the account holder who uses this platform to publish his own articles, and receiving comments also from third parties, third commentators. So the court here underlined the fact that the account holder cannot claim any right to impunity in the use he makes of the digital tools available to him on the internet. Indeed, relieving the account holder of all responsibility could facilitate or encourage abuses, whether it be hate speech and calls for violence, manipulation, lies, disinformation, fake news, blah, blah. For the court, there is little doubt that a minimum of control after the publication or a prior filtering intended to identify clearly unlawful comments as quickly as possible and then remove them in a reasonable time from the social platform, and even in the absence of a notification from the offended or injured party. So it's up to the account holder to act within the limits of what can reasonably be expected of him. While professional entities which created social networks and make them available to other users had certain obligations, there should be a sharing of liability between all the actors involved, stressed the court, allowing, if necessary, for the degree of liability and the manner of its attribution to be graduated according to the objective situation of each one of the actors. French law was consistent with such a view, providing in the case of the producer for a shared liability subject to safeguards of implementation, while in the case of hosts the liability remained limited. But you can ask that then what if I like this argument, what is the problem with the outcome? No, I think that here the process, the French legal context, and especially the court's approach to share the liability is really it's a very good approach. But nevertheless, I mean, for these remarks that drug dealers and prostitutes reign in the cities, I mean, for that there was a very sharp limitation of the. But okay, that's not the issue of this presentation. So just to repeat, who shared this liability according to the court innovative approach? The host, the professional who creates the social network and puts to the service of the users, the account holder, the Sanchez in this case, who uses the social platform to publish his own articles or comments. And it's at this point he might decide to allow others, users, to his platform or not. But in the case if the account holders permits third interveners to publish their comments, then there is a third actor with the shared liability, the third party commenters who makes comments and on someone else's account. So I think it's worth to note that the court specified the criteria and the factors to analyze the responsibility between the two or three possible actors, namely the nature and context of the remarks, secondly, the implementation of a prior filtering or an afterward moderating, and thirdly, the number of the visitors to the account, fourth, the deliberate choice to make access to the forum entirely public. So I mentioned that the account holder might limit the accessibility of the platform. Then the knowledge of the illicit comments of the third parties, then the speed of the reaction of the account holder, and the status of the account holder. This means that whether the account holder is a professional in internet communication strategy, does some expertise in the digital field, is a campaigning politician as in this case, because this, how to say, the reputation and the representativeness of the account holder determine the level of the responsibility. So the court said that a private individual with limited fame and representation will have fewer obligations than a person with a locally elected mandate who is running for such office, who in turn will have fewer requirements than a political figure of national stature, for whom the requirements will necessarily be greater, both because of the weight and scope of his or her words and because of his or her ability to access the appropriate resources to intervene effectively on the social media platforms. So I think that this opened up a new chapter in the developing area of legal responsibility of internet users and internet platforms, and of course that there are also some other cases that have the same, that deal with the same issue. But let me finish these few examples of the possibility of shared or responsibility, or as in this concrete case, shared liability. So let me, coming back also my December lectures, that with this shared responsibility, actually the court is facing the same problem as at a more general level with the universalism of human rights vis-à-vis the particularism and relativism, universalism and regionalism. So anyway, I think that European courts and the Strasbourg courts, first of all, is open to national diversities, much more than the Luxembourg court, which has a different policy and strategy. So, and despite the differences and the contradictions between the two courts, I think that our approach, also for historical reasons, is much more diversified and gives much more possibility for the national particular issues, margin of efficiency, subsidiarity, shared responsibility, and so on, vis-à-vis the European consensus that reflects a factual universalism of certain approach to human rights at the European level. But on a more general level, this dichotomy between the universalism and relativism, I think both sides of the coin are important, because with universalism we have to maintain a rules-based international order, which is very seriously challenged nowadays. The rule of law and international standards of human rights do not preclude the acceptance of unique solutions based on the traditions, specificities, or the identity of states in the case of restrictions on fundamental rights. So I think that this duality, the consideration of balancing between unity and diversity, makes really the work of the judges, our work, not only valuable, but if I can allow a personal remark, interesting. So I think with this I delivered finally a positive message to you. And thank you for that.
Dear Professor, thank you so much for your presentation. And we have received some questions from our experts. If I may, I'm going to read them. The first of these questions connected to the judicial system. Are the rules for organizing the judicial system, including the election of judges, the exclusive competence of the member states? Or can there be a European standard in this area which each state is obliged to comply with?
Thank you for the question. Also for the visionary question put before having heard my lecture, and it touches upon one of the burning issues of the last few years, especially. So our court, the Strasbourg court, was not very much interested in judicial independence for a long time, but then, I must say, decades ago, started very slowly and very restricted way to approach under Article 6, the fair trial article, the approach what is really this independent judiciary means. So it didn't came from the nothing when basically the Polish political situation regarding the legitimacy of the newly created judicial organs, councils, etc., the real legitimacy of the judges appointed by these councils, judicial councils and so on, became to the court. I was member of the first section of the court who discussed, who actually where these cases arrived as the Polish judges member of the first section. So I took part in some of this judgment, some of later on, as this is based on the membership in the concrete chamber within the section is based on different criteria. So I was not part of all these judgments at all. Some of the cases went to the Grand Chamber, like that I mentioned, Jeddah was basically opening up this issue with this judge of the Supreme Administrative Court that was dismissed. And so here the Grand Chamber worked out quite a coherent case law, and this set clear standards for judicial independence, which strangely enough was somehow partly overlapped with the Luxembourg court's approach. But for example, the Luxembourg court didn't want to pronounce on whether these judges are legitimate or not, who were appointed by this council. So it seems that in my personal view, there is a inner, how to say, struggle between setting up standards for judicial independence and declaring judgment on the appointment procedure, and restraint towards, how to say this, the question puts towards the national authorities. So in my view, both courts also entered in the merit of this problem, but maybe didn't step over their competence, or didn't want to be the, how to say, universal judge on the concrete cases in a concrete state. Let me mention a Hungarian example that concerns me also personally. When all the problem with the independence of the judges started, in my view, well, in Hungary, the judge appointed judges whose retirement age was 70. This was reduced by the legislation to 62, also affecting those who were in office. So not like in the United Kingdom for the future, but it also affected those judges who were in office. They had to leave almost immediately the judiciary. It came to the Constitutional Court, the issue. The Constitutional Court was completely divided, namely 7-7. And this was a very rare occasion when I, as president of the court, I used my prerogative to cast a decisive vote. So I had double votes, but I usually didn't use that because it's not fair. But in this highly politicized and, in my view, it's very important case, I used that. What was interesting, then the government response was to apply for the judges not this 62, artificial 62 years for retirement age, but to apply for the judges, also those in office, to the general retirement age in the country, namely 65 and a half, depending on. And the European Commission declared that this is a fair solution. In my view, it's absolutely not fair for those who were in office. And of course, those between 62 and 65 got back their position as judges, so stay anyway. So just to say that also the European Union sometimes is not so decisive on how to approach these issues. So I think, in synchrony with my approach, that I see this tendency of, how to say, apply uniform criteria for appointment of the judges. And here I can mention that we had the same time a very similar gun chamber judgment regarding appointment of judges in Iceland, so it was not by far limited to Poland. And I think that still the solution leaves a lot of margin of appreciation, if you want to say that, or flexibility to the sovereignty of the states.
Dear Justice, dear Professor, thank you so much. After this very practical question, now the second one, I think it's more theoretical. What is your general view on the so-called concept of multi-level constitutionalism, that is, the interaction of national, regional and global actors? Do you think the term is appropriate?
Very good question. I have a history with this question. So as I have written several articles on this issue, later I didn't review my views, but I abandoned the topic. But so my how to say, my opinion in force is what I have written 10, 15, 12, 20 years ago. Because I was approaching the importance of the constitutional courts, especially in the new democracies, of course also with a view of the Western countries that had a very... my starting point was that in Western Europe, or traditional democracies, you have a huge variety of solutions for constitutional review. Basically, the Constitutional Court as such was Austrian invention by Kelsen. Then after Second World War, Germany finally decided not to accept the pressure of the American authorities to imply, like Japan, American court system, but took over the German, the Austrian Kelsenian model. Italy went on the same way, and then the so-called second wave of democratization, Spain and Portugal found the same. Then in Hungary, the idea of constitutional review was raised already in the 80s, but the final outcome was a constitutional council with basically no powers. I think during the several years of their functioning, they turned down an administrative, regulative decision of local level. But the idea was always there in the academia, etc. And when one of these academicians who was promoting this idea, the research group on constitutional justice, became the deputy minister of justice, he put on political level, I'm still speaking of the Soviet, the socialist system. And so Hungary set up a constitutional court in January 1990 on the law, in books, but not in life. So it was not created until the political changes a few months later. And in the October amendment, huge amendment, basically new constitution, October 89, it introduced a real constitutional court that started to function January 1990. Before, there was Poland, who had already before the tribunal with limited powers, and on paper, the Czechoslovakia had a 1968 constitutional court that was never created before the fall of socialism. So it was present in the thinking of these countries, but then somehow finally also the Polish tribunal got full powers. I have to say that this deputy, the political draft of the socialist government was to have a constitutional court without the most important power, the right to turn down laws. So they not just. Then finally, also in the 90s, the Polish tribunal got this right, and under the pressure of the opposition, that finally in the constitution and the court law, the Hungary had a constitution with full powers to turn down all laws, parliamentary laws, and all other judicial, other legislative instances. What my interest was that the European Union, when preparing these annual reports on the countries waiting for accession, basically made a criteria to have an independent constitutional court with the possibility of full review. When I raised this issue at certain public conferences, etc., they denied it. That it was, how to say, by accident. So it was not this political requirement to have a full constitutional court in all countries, as was difficult to say, as Scandinavian countries do not have a completely different system, and so on. And so nevertheless, it was, or not a requirement, all countries who joined the European Union had an independent constitutional court, more or less with a full possibility of review of the legislation, and also a lot of rights to decide on constitutional complaint and so on. And then I realized that this multi-level constitutionalism is not a concept, it exists. In Germany, in certain land, they have 3 levels, because they have the land constitutional court, they have the federal constitutional court, and then they have the Strasbourg court and the Luxembourg court. My problem was that this multi-level constitutionalism that gives a solution for how to differentiate between the jurisdictions, gives a guidance, but nevertheless my conclusion was that it does not automatically improve the situation, to have such a variety of fora to go there. Sometimes it complicates the matters with contradictory case laws and so on. Then, especially with theorist of this multi-level constitution was Professor McCormick. Edinburgh, I was a friendly relation with him. We discussed it several times until he's passing away, unfortunately, quite early. So I disregarded this issue in the future, but that were my thoughts about it, let's say, until 15 years ago, so I cannot do anything, just repeat it, because I was not reflecting anymore. Especially I'm not in the position now to criticize the...
Thank you so much. The last question, I think it already was affected in your presentation or given parts. The European Union has not yet acceded to the European Convention on Human Rights. If this accession were to take place, what implications would it have for the Council's activity and for the coherence of the European human rights protection system? You are a lucky man because we have a little bit more than 3 minutes only.
Yes, it's a problem when someone is old and expressed himself on a lot of issues. I was, put it politely, very much surprised when in the constitutional draft of the Treaty on the European Union, this idea appeared. I didn't understand, because two so different things, and especially with my historical view to the Council of Europe and to the European Court of Human Rights, is based on originally on 10 sovereign states' acceptance of a certain international jurisdiction. How does the European Union, that at the time was even not a born idea, enter into this picture? I didn't express myself on it, so I have to confess that I was surprised. Then, after the failure of adopting this constitutional treaty, they upheld this provision finally in the Treaty on the European Union, and with that started an endless suffering of both parties. The European Union's starting to somehow to decide on it. This idea aborted several times, first of all because of the opinion of the court, Luxembourg court itself. Then there was always, depending slightly on the actual presidency of the European Union. For example, the Cyprus presidency, I don't know why, they were very much focusing on this. Fortunately, these half-year presidencies are not enough for anything. So then the idea aborted again. I was touched with that because I was member of this panel 255 of the Treaty on the Functioning of the European Union, this panel that evaluates the candidates becoming judges of the Luxembourg court. And during the Cyprus presidency, even the European Council realized that this is serious, so we started to work out how the 28 member states will appoint one single judge. Because I know as member of the 7 members panel that how many storms were before appointing a Hungarian among the 7 members, and I'm sorry to say, and not a Polish, because Poland is a much more greater country because I was representing 2 functions, the 10 newly member states and the constitutional courts. So I have a double role, and then the compromise was that if my term ends or I leave, because finally I left, then the new member of the panel will be Polish, Wierzchikowski. So they got it. And then how shall we choose from the 28 candidates the person, or how will the member state choose a candidate to send to us? But then this was over. So I was invited several times to discuss this issue, and of course there are always some formal steps ahead. Also last year, new protocols, but I don't see any changes in materially. So in fact. So what I'm expecting is a very long procedure, always postponing the issue, and so I'm skeptical regarding this, despite that I do not understand the original idea. I understand what was the justification, also to rule out, but and if I may remark, as a personal remark, but I think that with the entering into force of the Charter of Fundamental Rights, Luxembourg, in my humble view, evaluates itself as defending the fundamental rights in the Charter in a much more effective way on their field, that the Strasbourg Court can do that on a completely different ground.
Dear Professor, dear Justice, thank you so much for your answers. And please let me grab the opportunity to express our gratitude for your essential support, not only in connection with this event, but as of the previous years. And I hope that we can continue this kind of activity, this kind of cooperation. I would like to ask you for doing this. Thank you so much.
Really,
thanks.
mutual.
Thanks.